We are at 410. Good afternoon. My name is Phyllis Hildreth. I am the chair of the Metro Human Relations Commission, and we welcome you to our regularly scheduled, publicly noticed monthly meeting. This time we will move into our regular business and then take ourselves to the agenda item, the topic for today, where we will receive an educational presentation about how our government works, Money Bell in Nashville. So at this time, without further ado, having just called us to order, I'd like to formally welcome our guest for today, Dawn Diener, Public Defender from the Office of the Public Defender. Welcome. And also Glenn Funk, District Attorney, Office of the District Attorney. Welcome, General. Thank you for attending. At this point, we will seek to confirm quorum, and I believe that miracles never cease. If Dr. Pryor, we have 1, 2, 3, 4, 5, 6, 7, 8, 9, 10 of the 17 appointed commissioners for this board, so I declare that we do have a quorum and may proceed to complete our business. At this point, I will turn for review and approval of the minutes. Commissioners did receive these minutes in advance. I believe that they are also posted publicly on the website. Commissioners, knowing that you have had an opportunity to review the minutes in advance, is there a motion to accept as submitted?
So moved.
Any discussion, corrections, or deletions? All in favor signify by saying aye. Aye. Opposed? Thank you. The moments are approved and accepted. At this point, I'll ask Executive Director Mel Fowler-Green to offer the financial report.
Thank you, Chair. The financial report remains much as it was last month due to a staffing opening for just about 2 months of this fiscal year and the fiscal responsibility of your executive director and her staff. We are doing very well on our budget. In fact, we have a good chunk of money that we can spend on a couple projects for the remainder of the fiscal year. I don't believe that there's anything extraordinary to explain in the budget. I am, however, open to any questions if you have any.
Are there questions? Hearing none, we will receive the report. According to our bylaws, we do not need to take further action on them at this time. So with that, moving right along, we come to the new business for today, and that is the discussion We Serve the City, charting our course for education advocacy. At this point, I'd like to take just a moment to remind the commissioners and also share with our public that we welcome in our meeting today, and also those who may be viewing this on the video at a future time, that one of the important roles of the Metro Human Relations Commission is to ensure compliance, encourage compliance with Title VI of the Civil Rights Act of 1964, which states, "No person in the United States shall, on the grounds of race, color, or national origin, be excluded from participation in, be denied the benefits of, or be subjected to discrimination under any program or activity receiving federal financial assistance." And what that means is a practical matter that we who enjoy the benefits and blessings of the civic operation in Metro Nashville are receiving services and benefits that are in some way funded federally. So it means that the non-discrimination requirement is incumbent upon all of us who provide those services. So if we are to understand what the provision is and whether or not there may be some concern about whether receiving them equitably, it's important to know, what does our government do and how does it work? And to that end, we have determined as a commission that one of the ways in which we execute our responsibility to you is to provide opportunities for public education to learn how do the units of your metro government work. To that end, we have today's presentation, and at this point, I will turn it over to Executive Director Mel Fowler-Green to explain and introduce further. Thank you.
Yes, thank you. So this fiscal year, the commission is committing just about half of our public meetings to an educational program. We serve the city, charting our course for education and advocacy. Each one of these educational meetings is going to focus on generally one governmental body or function with the intent of educating the commissioners, commission staff, and the general public. Each educational meeting is, the topic is determined by consensus through the commission. So given the significant conversation locally about the use of money bail in our criminal justice system, we've invited Nashville District Attorney General Glenn Funk and Public Defender Dawn Diener to help us better understand the system and the role that their offices play. So I really want to start the questioning by first saying thank you very much, both of you, for your time and your willingness to participate in our educational program. So thank you. So I would like to go ahead and start, if I might, with Public Defender Dawn Diener. And what we have done is we, in advance, asked both of our guests 3 basic questions. One is, what is this money bail thing about? Right? What's the intent of bail? How is it set? We asked what piece of the system your office touches, and from your perspective, what sort of high-level information might constituents need to know to better understand how their government functions in this topic, and what the local conversation is about the use of bail, right? So I think you'll have about 15 minutes, Dawn. Great, thank you.
Thank you, and thank you all for having me here. I hope this will be informative and useful to you. So what is money bail? Well, money bail is the primary means by which individuals who are arrested in Nashville, custodially arrested, taken into custody by a police officer and taken downtown to the jail. It's the primary means by which those individuals secure their release from jail pre-trial. And so it is, if we think about the concept of presumption of innocence, when you are arrested, you may be charged with a crime, but you are presumed innocent. You can have and should not have a trial immediately. And so the way most individuals in Nashville who are taken into custody secure their release from jail is through the use of what's called money bail system. So I want to talk a little bit about how that works, how that process works, and how the money bail process works. So a person gets arrested by a police officer. There are 2 ways in which that arrest can be dealt with by police. The first is by a citation or a summons. If you receive a citation, you actually don't go into custody then. The officer writes you a citation on the side of the road. You will be given a date to appear a few weeks later down at the courthouse, where you will be booked. At that point, you'll be fingerprinted, your mugshot will be taken, and then you will be sent across the hallway for court proceedings. Citations are only issued in misdemeanor cases, but some of the good news about today is that Nashville, about half of the individuals who are arrested in Nashville each year are arrested by citation. And so in last year, I think that averaged about 30,000 individuals who received a citation last year instead of being taken into custody and taken down to the jail. The vast majority of citation cases are actually for driving on a suspended license. And so they are minor offenses, but that's positive information coming out of Nashville, that we do use our citation statute here, and that avoids a lot of people going into custody. For anybody who does not receive a citation, and that's anybody charged with a felony or who will be charged with a felony, and many, many misdemeanor arrests, they are actually taken into custody by the officer, taken to what we call night court here. It's called night court, but it runs 24 hours a day, 7 days a week, 365 days of the year. And with the Criminal Justice Center under construction right now, that night court is actually operating in a mobile trailer behind the Hill Detention Center down on First Avenue. The defendant is not actually taken there. The defendant is taken to jail. The arrestee is taken to jail. And that hearing that happens there is conducted via video conference. And so the police officer oftentimes is video conferencing in or maybe standing in front of the commissioner, but the arrestee is generally either at a remote location being video conferenced in. And so what happens at that hearing is the commissioner sitting there, who is an employee of General Sessions Court and is supervised by the General Sessions judges, has to make two decisions. They have to decide if there's probable cause to issue an arrest warrant. Is there probable cause to believe a crime was committed? And if so, then what's the appropriate decision around release on whether or not that person should stay in custody or get out of custody or has to make a bail, generally speaking. Now, Tennessee, under Tennessee law, statutes, every person has the right to bail except for an individual charged with what may very well be a death penalty murder case. And so pretty much everybody who comes through night court charged with any kind of offense, misdemeanor or felony, has a right to pretrial release. So the decision the commissioner has to make is, well, how do I deal with that release? So there's actually a schedule. There's actually statutes that say which options are available and the order in which those commissioners are to consider them. So the first option is release on your own recognizance, which says that we believe that you will come back to court and you are not a risk and you're vouching for yourself, and so we're going to release you. The primary purpose of the bail, of this decision and of the statutes is to ensure appearance in court. That's what the commissioner is supposed to be considering, is what do I know about this person that tells me they will come back to court when they're required to be there. So the first option is release on your own recognizance. The second option is that if the commissioner believes that just releasing somebody on their own promise to come back to court isn't sufficient, they can be released into a program that is a supervised program run by the county. And they can be also placed on an unsecured bond. So what is that program? It's what we call pretrial release, which is operated here in Davidson County by the Sheriff's Office. If you are placed on pretrial release, there's a very minimal fee to be placed on that program, but there's no other cost. And pretrial release essentially supervises you, make sure you know about your court date and that you come back to court. The other option is an unsecured bond, which means a money bail can be set, say $1,000 for a misdemeanor, but you don't have to pay anything up front to get out. A bail is just set. You get out. If you do not come back to court, then you will be on the hook for paying the $1,000 that you owed in. But to get out, you don't have to come up with any money. The third option, and is the last option, is a secured bail, which is what when I say money bail, and when you hear the term money bail, somebody is talking about a secured bail. And we're going to talk just a little bit about the ways in which, if a money bail is set, how do you get out of jail? Okay? First option the commissioners to consider is ROR, release on your own recognizance. Second option is unsecured bond or pretrial release. And the third and final option is a secured bond. You'll see some data in a minute that shows you, at least as long in 2016, the commissioners here in Nashville almost exclusively go to money bail. Very few people are released ROR, and the percentage of people who are getting out on pretrial release, particularly for misdemeanors, is very small. And so the vast majority of individuals are being placed under money bail requirements. So if money bail is set, how do you get out of jail? Well, pretrial release still comes in, and in fact, the way our system currently operates is that a money bail is set before pretrial release even considers whether or not you should be released through their program. But pretrial release can get you out. In order to get out under pretrial release, you must qualify under their criteria. And those criteria were set many years ago by the General Sessions judges. And so they limit the number of people who get out, and you'll see a little bit about that in a minute. The second option is you can pay what's called a cash bond, full amount. So if my bail is $1,000, a family member of mine can go down to the clerk's office, deposit $1,000, and I will get out. And when my case is done, assuming I go to all my court dates, I will get my $1,000 back. with one exception. If I was convicted and I owe any money, court costs, fines, anything like that, those fines and court costs will be deducted from my cash bond, and I will only get the balance back. So if I paid in $1,000 and I owe $500, I will get $500 back. The third option is a property bond, which means family member can post real property if there's enough equity in that property to cover the cost of the bail. And I don't remember the ratio today of what it is. It has to be, it's not a 1-to-1 ratio. So if you have property with $5,000 of equity, you cannot make a $5,000 bond with that. It would have to have more equity. The last option is secured bond, a bonding company. And this is the option most people end up going with when they manage to get out of custody pretrial. So how does this work? If my bond is set at $1,000, then my family member, who will co-sign for me, will go pay $100 to a bonding company. 10% of the bond gets paid to the bonding company, and that is their fee for their services in monitoring you and taking on the risk of you not coming back to court. Because if you don't come back to court, the bonding company is on the hook for the $1,000 that your bond is. You've only paid them $100. They would have to pay in, if they cannot get you back into court within a certain time frame, they will have to pay that full $1,000. Now they will go after your co-signer for that. And they will certainly come looking for you before they have to pay that money. But that's how the surety works. And I will never get that $100 back. That's the cost. And so if I am wrongly accused of something, and my bond is set at $10,000, and I pay a bonding company $1,000 to get out pre-trial, I'm out $1,000. If you cannot do any of those four things, you will stay in jail pre-trial. Point blank. If you don't qualify for the requirements under pretrial release, and then you don't have cash, property, or somebody willing to post money with a bonding company, again, cash, you stay in jail. And that is the crux of where, frankly, the public defender's office comes into play, because the people who stay in jail pre-trial, many of them are our clients. And one of the biggest injustices we see for our clients is the inability to get out of jail pre-trial and the coercive effect that has on people when making decisions around plea bargains, and the detrimental effect it has on their lives in just a matter of a few days of being in custody. So this is the bail data for 2016 for misdemeanor cases in Nashville. And what you'll see here is that in 2016, there were almost 21,000 cases involving individuals who were just charged with misdemeanors. And in 2016, the average bond amount that was set for those cases was $5,244, which means that it would cost the average person charged with misdemeanors $500 to get out of jail pre-trial if they made bond through a bonding company. The additional information that you'll see here is that of those 20,800 and some defendants, only 8,500 of them got out of jail before their case was resolved. The remainder of them remained in custody until their case was settled. So that's an average, that's 41% of misdemeanor defendants who are getting out of jail pre-trial, and 59% of them staying in custody until their case is resolved. And this is just misdemeanor data. We're not looking at individuals charged with felonies here. So when you look at some of those numbers, the chart below shows you how people in 2016 actually secured their release. And so a cash or a credit bond, which is the first line, shows that 172 people of the almost 21,000 made a cash bond. So very, very small numbers that we're talking about here. Only 83 people got an ROR. The first thing that the commissioners are supposed to consider. Only 83 people in the almost 21,000 were released on their own recognizance. 1,753 people got out on pretrial release. So, and then these are misdemeanor numbers, but it's 20% of the people who got out, But when we're talking about 1,700 people in a size of almost 21,000, you can see that the pretrial release program really isn't getting a whole lot of individuals just charged with misdemeanors out of custody, pretrial. And then the last line, the vast majority are making bond with a surety company, so 6,557 of those individuals. The number that I really want to talk about, though, is the bottom line number, that 12,318. Those are our clients. Those are the people who plead guilty to get out of jail, who plead guilty not because necessarily they are guilty, but because it's their quickest way out, who plead guilty because they have jobs, families, responsibilities outside of jail that they need to be home for, and they cannot afford to pay their way out of the cage that is holding them. So this is just some numbers to let you know who we're keeping in our jail. On the average day in September this year, almost 1,000 individuals were being held pretrial on felony charges, and on an average day, 107 were being held just on misdemeanor charges. So 56% of our jail population are pretrial detainees. The reality is that bail bonds are a lucrative business. This is a report from 2016 that shows that at the end of the year, in Davidson County alone, surety bonds totaled $126 million, which meant that the bail bond industry in Davidson County would have brought in 10% of that, or $12.6 million. Frankly, it's not this number that bothers me, though, because my clients are the ones who don't pay bail because they can't afford it. And so it's not this number that bothers me, it's the number of individuals who cannot pay to get out. I think that we face many challenges, and I hope we'll have a longer conversation about those, but those include the fact that we, frankly, as a community, have forgotten many times about the presumption of innocence. The fact that somebody has been arrested does not mean they are guilty. And I think any one of us who has somebody we care about arrested would want that person to be able to enjoy the presumption of innocence, which being in jail seriously impedes. We have public safety concerns. I suspect you're going to hear from Mr. Funk here in a minute about protecting public safety. I think we, in many respects, kid ourselves if we think that using money to keep somebody in custody is what protects us. If I am charged with aggravated assault and my bond is $10,000 and I have money to get out, I'll be out. If I am charged with aggravated assault and my bond is $10,000 and I don't have any money, I'll be in. And there's nothing that differentiates me having money and me not having money in safety. And so that we use money bail as this notion that it somehow keeps us safe, when really there's no evidence that just because somebody has money, they are less risky to us or to a potential victim, is really poor logic. So we do have a Nashville Community Bail Fund. I don't want to go into a whole bunch of that, how it works, but it's a revolving fund, basically a pay it forward, that is designed to stop, to sort of disrupt this process and this thinking around money bail being really an evidence or being something that shows people are more likely to return to court or are less risky. The bail fund has been operating in Nashville for a little over a year with a really high success rate of getting people out, them coming to court, and them not having any further problems. Showing, again, that having money doesn't make you less of a risk. So I will stop there.
Also post on our website a link to this video and to any material or information that either of our guests would like to share with constituents along with this video. General Funk, if you would now please give us your perspective from your office, and I'm going to run up there and help you click on that thing. One of my many hats.
All right, we'll get to that slide in a minute. First of all, I want to thank everybody who's here today for their work. Appreciate your concern about this very serious issue. Bail does two things. Number one, it is designed to ensure someone's presence in court when their case is back on the docket. And two, it's designed to protect the community and protect individual victims. Victim of a crime does not need to be abused a second time by the defendant while their case is still pending. And before we talk about any issues, I like to hear from victims because it is a very important aspect of a human rights commission is your basic and fundamental human right to safety within the community. I brought with me today Sparkle Johnson. And Sparkle, if you could step up, and I'd like for this group to get a chance to hear from you. Sparkle, I really appreciate your being here and having the courage to talk to this group. If you could just tell this group a little bit of your story and what happened to you in the last couple of years.
Okay, so first of all, good evening. How you doing? So this 2 years ago, I was a victim of domestic violence. Had been for 5 years, but finally wanted out. Unfortunately, this was a time where it almost cost me my life, to the point I was beaten, tortured, videotaped, cut, pistol whooped, all of that. And while that's one of my 3 children were in a room with the door shut, no food, no Pampers or anything for a couple days. And when he was finally arrested, my abuser, when he was finally arrested, he was making deals with his cousin, who's also a politician, on how to get out. And the bail was brought up. He was out on bail for, I don't know, a week or two. And the entire time, him and his cousin was plotting on my life, on how to keep me from going to court by any means necessary, to the point the cousin even tried to meet up with me. And I actually was going to meet him, and the only thing that stopped me was picking up my children from school. Got stuck in traffic. But and I often wonder if that was the day I was gonna lose my life. Now, he was rearrested after we found out some things going on with the bail that was illegal. And in the middle of that, even after that, it was jail phone calls released on, again, trying to get out, at least the legal way of bonding out, and still going through with the plans of taking my life. And let me just say this, I did stand up for myself. I did go to trial, and he is convicted, and I feel 100% safe for me and my 3 babies. But it was scary the whole time, knowing that the bail was possible, because just like Ms. Dondina mentioned, he had money, and that was terrifying for me because I knew that he could get out. So when they locked him up without a bail the second time, I felt safe. I definitely feel safe now. And what little I've heard, that revolving recycle money thing, that terrifies me. That even though they say he wasn't, I guess, innocent until proven guilty, he was guilty, and was trying to continue to be guilty every day that he was in there and out. I often wonder, it doesn't really matter now, but I often wonder if now he's even trying to hire somebody to take my life or whatever the case may be. It's a constant wonder. So that recycling money that scares me, that somebody could get out. And I understand that every case is different, but it was mentioned up there, domestic violence. And that was my case in the worst case of scenarios. And that's all I have to say about that.
All right, and Sparkle, if this was a situation where he was just continued to be released every single time that he'd been picked back up, would that have had an impact on you or your children children's lives to know that he was right back out on the streets without having to post a bond or having to answer to anybody?
In his words, I would have been dead and my kids would have been kidnapped with his mom in another state.
Okay. Well, listen, we really appreciate your being here, and that really helps kind of have us focus on the fact that victims have rights too.
Thank you.
Thank you for being here. I'd also like to let the commission know that Mackenzie Shanklin Brett is present. She's our Director of Victim Witness Services, and she deals with victim issues on a daily basis. That's what she does, is try to support victims, and that's really kind of what we're about as a district attorney's office, trying to make sure that the community's safe, trying to make sure that we support victims, trying to make sure that the community's healthy, while at the same time making sure that the system is perceived as fair. As Ms. Diener has discussed, we are in a really good position in Nashville in that, unlike almost every other community in the nation, half of all of our criminal charges are handled by a citation, which means no one goes to jail even for a minute while the case is pending. Of those situations where someone is actually arrested, a bond is set within the first couple hours of their incarceration. And if they stay in jail more than just a few hours, they are in front of a general sessions judge currently within 24 to 48 hours for a bond review. And so they are not just held and languishing in our jail without having a general sessions judge actually be able to address their individual concerns and the concerns of that case and the concerns of victims. And everyone in Nashville has an opportunity to have either a preliminary hearing or a trial, if it's a misdemeanor, within 10 days. So the horror stories that we hear from around the country of people being stuck in prison in Manhattan for 6 months on a drug paraphernalia charge don't happen here. You get your trial or your preliminary hearing within 10 days. So in some ways, we are among the best in the country already. There are ways where we can make our system even better. Ms. Diener talked a little bit about how many people do not make bond on misdemeanor charges. And roughly, that's about 12,000 people a year. And those are for all misdemeanors. About 12,000 of those folks don't make bond prior to having their cases resolved. Her quote then was, "These are the people who plead guilty in order to get out of jail." But that's not exactly right. The sheriff put together a chart of the top 10 most serious misdemeanor arrest charges and the top 10 most frequent arrest charges. This document indicates that public intoxication, the number of charges were 3,586 individuals in 2016. 3,586. You know what happens on a public intoxication charge? After 4 hours, the case gets dismissed. You don't even have to go to court. That's part of the 12,000 that she's talking about. That leaves you with about 8,500. 8,500 is not zero, right? I understand that. But it's not 12,000. And if you take the rest of the cases, a lot of folks come to court the next morning and they have simple possession of marijuana or some other controlled substance. They might have a drug paraphernalia charge. They might have a theft of merchandise. The criminal trespass charges, there were 1,666 where that was the most serious charge. And I can tell you that almost every one of those was out within 24 hours. Now, the average time in jail for defendants that did not post bond, if we can go ahead and pull that up. Now, I just need to touch this.
Yeah, go ahead. There you go. And
Got
then.
it? Now I'm back on Dawn's presentation. We don't need to hear that again. Which click did you hit? All right. So of the.
You need it bigger?
No, that's fine.
Okay.
I think that's plenty. You can see that the public intoxication, those folks stay in jail for less than half a day from the time they're processed in to the time they're actually processed out. Other crimes include things such as DUI third offense. That's a misdemeanor. Carries up to 120 days in jail. Sometimes those individuals are going to stay in jail because we're waiting for a blood test to come back, and then they plead guilty once their blood test comes back, but they want to see it before they plead guilty. So that number skews, and the domestic violence related is skewed as well. Average length of time for domestic violence related, 8.59 days. There's a lot of people who are in jail that are in jail all the way up until the 10th day. And then there's some that get out of jail even sooner than that, if we're able to put it on the docket and resolve their case before that. But that average time on domestic violence related cases does in fact skew the total amount of time that folks are in jail. But I make no apologies for the fact that we are doing all we can to make sure that victims of domestic violence are safe and that they're fully supported. Ms. Diener says that there's no evidence that this keeps victims safe. I would disagree with that, in that if someone who has beaten, abused, strangled an intimate partner on a domestic violence case is released, then many times that person is going to be victimized again. Now, her point that some folks who have the ability to post a cash bond do get out, I understand that, all right? And we are doing all we can to try to get these cases heard as quickly as possible in a way that fully supports the victim and recognizes the defendant's constitutional rights. I have passed out to the group a letter that I sent to Judge Mondelli that contains a flow chart that I think is part of what I was asked to do for this, is kind of explain how our office comes in contact with the bail system. The flow chart shows that a police officer makes the decision on whether or not to arrest. If it's a domestic violence case, then they do what's known as a lethality assessment at that time too, and that is not a public record, that lethality assessment. The individual who's been arrested then goes in front of a night court commissioner who determines whether or not there's probable cause, and if there's no probable cause, the person is released. If the commissioner finds there is probable cause that an offense was committed and probable cause that this person committed it, then I suggest that the Davidson County Sheriff's Office should at that point conduct their pretrial release assessments as the commissioner decides what the bond amount is set. Currently, the commissioner goes ahead and sets that bond just looking at the defendant's record and hearing what the facts of the case are. At that point, I would suggest that the commissioner do a pretrial release determination, and if the misdemeanor, or felony for that matter, is not on an excluded list, then the commissioner could order pretrial release through the Sheriff's Department, which is a system where the Sheriff's Department essentially posts the bond for the individual. But certain crimes should be, and I think are properly committed, an A, a B, or a C felony. A felonies being things like second-degree murder. B felonies being things such as, let's see, aggravated robbery, using a gun to commit a robbery. C felonies, which can be things such as voluntary manslaughter. Also, I think that should be excluded from a pretrial release determination at that point within minutes of the arrest should be any domestic violence misdemeanor, any third offense DUI, or if the individual's had 2 prior arrests within the last 6 months, or has pending charges, or has failed to appear on this warrant, or is on probation or parole at this point. If it is one of the excluded offenses, then they still have the ability to make their cash bond that night. But if they don't make bond, my proposal is, and this is a slight tweak to the current system, is that we have a judicial bond determination, a hearing the very next day. And at that judicial bond hearing, we can have the statutory factors that the legislature put into the form of the Tennessee Code, of the things that a commissioner or a judge should look at for an appropriate bond. The Davidson County Sheriff's Office assessment, any proof offered either by the defense and the defense counsel as far as why this person is not a threat and this person is going to come to court, and proof from the state where we can put on a victim if they want to testify, or we can put on proof about prior criminal activity or why we believe this person's going to continue their criminal activity, and recommendations made by the defense attorney and the district attorney. These next business day judicial determinations, very prompt. We're talking about arrested one night, you're in court the next morning. If the judge, after hearing all that, orders pretrial release, then the person can get out without having to post a cash bond. But if, after having this hearing, the General Sessions judge determines that there should be a cash bond requirement, then that cash bond requirement is left in place, and the individual can either make arrangements to make that or ask a criminal court judge to review what the General Sessions judge has already decided. So there are roughly 5 release points here, with some additional release points if they later on make a bond or have a judge, a criminal court judge, review the facts and the issues with regards to the case. As the district attorney, I do believe in cash bonds on certain cases. The police department is charged to go out and make arrests on cases where someone has committed a crime. They do that, they bring them in. They bring them in. If that person then does not show up for court because we've had the sheriff's department release them, or because we've had an ROR bond, then how does that person ever come in front of the court? Well, the police have their hands full making arrests of people who have committed crimes today. They don't need to be spending all their time worrying about folks that they've already arrested once 6 months ago or a year ago or 3 months ago who chose not to come to court. That's not their responsibility to keep having to make the same arrest over and over again, but if they've made a cash bond, then it's up to the bonding company, in order to make sure that they haven't forfeited their money, to go out and find the person and bring them in front of the court. And that's what they do, so that our police can be in charge of keeping our streets safe from the crimes that happen on a daily basis. The proposal that I have gone over and that you've got the flow chart for, I think properly balances public safety concerns, balances the rights of crime victims with the rights of defendants. I appreciate Ms. Johnson's concern that she doesn't like someone who did what the defendant in her case did to her. She doesn't like the thought that he would be out. And we did our best to make sure that that case was brought to trial promptly, and we were fortunate enough to secure a conviction and have him sentenced to the penitentiary. We have to balance those rights with a person's constitutional right under the Tennessee Constitution to have a bond set. But that is not a constitutional right just to get out of jail for us to have to catch you all over again and all over again and all over again and all over again. We've got to, as a community, be smart about the way that we deploy our resources, and we've always got to make sure that our ultimate goal is public safety.
Thank you, General. Would like to take this time to thank both of our speakers for providing a very educational, enlightening presentation about a difficult topic. As we indicated at this time, I'm also going to explain a little bit of process. First of all, these education sessions are new for us, so we're still finding our way. Second, when we ask a unit of government to come in and tell us how the government works, it's usually one office, so they can give their own point counterpoint. And one of the things that quite transparently we needed to negotiate for this session is that it would not be a debate, it would not be a confrontation, that we were going to provide a service to the city by providing education from the primary sources. That being said, many of us have questions. I understand that. And part of what we need to do as we craft and execute good public process together is allow for that. So please allow me to suggest that this is what will follow next. Commissioners, we will ask you to submit to the Executive Director's office in writing questions that you have for either or both of our presenters following this meeting. We ask that you get them to us within 7 days. From that time, the executive director will craft a list of sheets, assuming that maybe some of them may come together, and send the same questions to both the public defender and General Funk, and ask whether you would like to respond to them in writing, with the understanding that we would like the opportunity to post both our questions and your answers on our website, so that those who are present and those watching the video may continue to watch, if that's acceptable to you. So that would be first. Second, and I'm sorry, I should have done this first, I need to stand and thank Ms. Johnson, where I can see you. Thank you. Thank you for the time, the courage, and the clarity of your voice. We know that that was a great amount of public service that you have rendered out of your personal space. I personally appreciate that, and I believe I speak on behalf of the commissioners for doing that, so thank you for that. Having said that, there are many stories out there about how this affects persons. And so I would also like to give Public Defender Diener an opportunity that if there is a clip or an exemplar that you would like to point us to, that information would also be made available. And General Funk, the same thing. If you all have your favorite, this is why our stuff is right, YouTube, let us know. We'll take the links and put them up. But we want to make sure that the stories are unified and balanced. Next question. I know that this was asked by Commissioner Poster, but I'll reiterate it. You've given us excellent data. We are requesting, if at all possible, that you would give us either copies of your data to post on our website, or if instead you would like to give us a URL to point us to a source of data that you would like for commissioners and citizens to look at, we would find that very helpful. Also, I just have a question as to whether or not there might be a way in which the two of you would have an agreed statement of facts. This is not a homework assignment, but, and one of the reasons I ask that is also in transparency is we know that both abroad and particularly in this jurisdiction, questions of bail reform are going to come up. And it's going to be important for our commissioners and our citizenry to have an idea of what does that even mean. It sounds to my ears that both of you said a lot of overlapping information. If at some point a joint statement of what you both agree on is something that either you want to put on your websites, have us point to, or present to us to offer on your behalf, we would be happy to do that. Also, General Funk, you started us off by giving us this wonderful flow chart and talking about a plan for change. Public Defender Diener, if you have a similar chart and plan, it would be nice to have both of those to post and again see if we have some overlap. And ultimately, as we close, we'd like to give each of you 2 minutes, and 2 minutes, to say final words either in response to what you heard each other say, or what we just offered, and maybe incorporate this last question I have for you is what else do you want the citizens to be thinking about, knowing, and asking you, and how can they contact you or your office directly if they have questions? Commissioner, I'm holding all commissioner questions at this point. I'm going to ask you to submit your questions in writing, and we will go that way. Thank you. So at this point,
I think that what I'd like people to know is that somebody charged with a DUI third who's waiting to get their blood test results isn't just waiting to see a blood test result that's going to show they're guilty. They're waiting on a blood test result that's going to show that they're innocent. And if they have spent 90 days in jail waiting on that blood test result to come back to show that they are innocent, then they have been distinctly harmed. And they have been harmed purely because they are poor, purely because they do not have the money to make bail. And I think that's an issue that this county needs to wrestle with seriously. Mr. Funk can bring in witnesses who will absolutely have had terrible experiences. I understand that, I do. And I don't think bail reform solves all those problems. We don't have preventive detention in Tennessee. You don't have a system that starts out with a presumption that you stay in custody if somebody thinks that you're extremely dangerous. And in fact, what we heard was an example of somebody who had money and was able to get out and was still dangerous. And so I think those are the issues that we have to come to grips with, is the fact that money doesn't keep us safe. And so what are we really doing here?
Thank you. Thank you. In general, you have the last word, 2 minutes.
I think it's important to remember that Ms. Diener and I have different jobs. She is an advocate. She's an advocate for her clients. She is an advocate for people who are accused of crimes. I have a different job. I'm the district attorney. My job is first about public safety and individual safety. And it's also to protect the rights of all citizens, citizens who are victims of crime and citizens who are charged with crimes. And that's a balance that has to be struck by the people who are the judges, by the district attorney's office, and by the citizenry who charges their government with trying to make sure that their community is safe. And so when we balance all that, I think every one of the judges is committed to trying to make sure that the system works even better. I know that I am, and that's why I presented y'all with kind of what our suggestions were to Judge Mondelli as our community as a whole. The 11 general sessions judges, the criminal court judges, and the mayor's office works together to try to make sure that we've struck the right balance. And we appreciate the input that this commission will give to us as we work forward.
Thank you. We thank you both for your service, Commissioner.
I don't have a question, I have an observation. Well, a person like me who doesn't really understand what the issue is, there seems to be somebody for something and somebody against something. I was not really clear about what that something is. So it seems to me that perhaps that should have been set up in the beginning if there's some conflict about what's going on in that office, or maybe even what money bail is. So it seems to me it would have helped to lay out what the pros and cons are from each side on that. That's my concern.
Thank you. So we will make sure that as we put the follow-up to this session on there, that we may have a couple of paragraphs or primer of what the bail system is. I believe that Ms. Diener's presentation covered some of that, but we will bring that out very clearly and frame it. We thank you both for your service. You are welcome to stay as we continue with our public meeting, or to go. I know that you have other things to do. Thank you.
Thank you.
So at this point, we will turn to the director's report.
Now just wait a minute.
We'll just wait a
people
minute.
are
I know, I'm
shuffling.
being excited, trying to get us.
Thank you.
Thank you.
Right, Director's report. Hi, everyone. This will be our last meeting of this calendar year. And having had a enlightening conversation, I'm going to keep the director's report this month relatively short. I do have a couple of important updates on some work that we have done over the last year, and a couple announcements to make. If you will recall, about a year ago, almost exactly a year ago, this commission issued a formal letter to the mayor's office and to the chief of police, Chief Anderson, citing concerns regarding Title VI compliance after a grassroots organization, Gideon's Army, released a report called Driving While Black that detailed alleged racial disparities in traffic stops and searches. So in November of last year, this commission raised concerns about that data analysis and and basically asked what was the city's obligation, having seen that data, to comply with Title VI. The commission made a recommendation that a independent task force be impaneled that had access to not only the data, the traffic stop and the search data, but also other data sets that have been viewed by agencies like the Department of Justice as being an important metric in measuring Title VI compliance, particularly data related to discretionary charges. We had several conversations with the mayor's office over the last year about that recommendation. And as you will recall, following the fatal police shooting of Mr. Jacques Clemens, we asked for assistance from the Community Relations Service of the Department of Justice on really recommendations on best practices for engaging constituents and for advocating for the recommendation that this commission made last November. I'm very excited, cautiously excited and optimistic to announce that Chair Hildreth and I were invited to a meeting last week with a team from the Policing Project at New York University. Also in attendance were members of the mayor's staff and our two guests, actually, from this evening, the public defender and the district attorney. The Policing Project is putting together a research team made of social science experts from all over the country. They're being given access, as far as we understand, to all police data, and they are going to work with the community to design a robust analysis of current policing strategies. While their main focus, my understanding is that they're interested in designing a sort of robust cost-benefit analysis of policing strategies. But I think, and Chair Hildreth can agree or disagree on this point, but I felt fairly confident that that analysis would also speak directly to some of our concerns with Title VI compliance. So, given the scope of their work and what they're currently contemplating, the community engagement that they're proposing, and the apparent participation that they're having by MNPD, I really am fairly optimistic that this endeavor will address many of the concerns that we expressed last year. So I want to say thank you all for the courage to come forward with that bold recommendation a year ago, and for the support that you all gave me and Chair Hildreth, and our former Chair True, absolutely. Yes, Frank True went with me to the first meeting with the mayor's office about that recommendation. And I've always said this about Frank, that, you know, he could be so kind that I think that people underestimated his strength. And he was an incredible advocate on this point. So I think he would be very proud of this body for carrying that forward and advocating over the course of a year. So, good work, you all.
If I just say one, I totally concur in the director's report on this point. One of the reasons we intentionally began this session with a reading of the capsule of Title VI is to remind us of the power of what it means to look at there shall be no discrimination or exclusion from participation in or be denied the benefits of or be subjected to discrimination under any program of. That is exactly what happened here. And to wit, the meeting that we had this past week, one of the questions that was asked by the policing project persons coming in is whether they should just be looking at policing for allegedly underserved or mispoliced populations, or should we be looking at policing in Metro generally? And it was your director and your chair who sort of sat and had sidebar and then put hands up and said, actually, it would be important to make sure that you looked at the whole city. Otherwise, we will not know if there is a disproportionate provision or withholding of services in one neighborhood or another, or what it means. What does policing look like as a proper baseline for Title VI? Therefore, how does one know if there's a violation? So again, going back to our core purposes, going back to our enabling statute became very powerful in the prosecution of this one-year articulation of need and the administration's response thereto. So I want to commend you on holding the line there as well.
Thank you. Sure.
This policing project being put together, this effort to have all data to analyze policing and what's being done, this sort of stuff to get some clarity. What's the next step after that?
Wow.
Sorry, yeah, will you repeat
Wow,
the
I'm
question?
surprised. I don't usually need a mic. What I was asking was this policing project that's being developed that's about getting access to all data and then analyzing that data to get an understanding of policing and maybe a broader aspect of compliance with Title VI. Okay, I get all that. But then what's the next step? Because here it is again, this idea of which, of course, as a social scientist myself, I want the data too. And I find the data to be very important. And when we have the concerns that we do with policing, certainly transparency about data is important. But then what? This is one of those places where I sort of feel like, while I'm in agreement and hopeful and proud as well, and I think that that's a step in the right direction, it seems like it could be an end point that then again is just this, like, again, we have more information, but what's going to happen?
Well, quite frankly, if there is data that indicates a disparity under the paragraph that I just read to you, then this commission is empowered to go forward and allege a colorable violation and begin to exercise its duties under that. So if we find that in one zip code, policing happens one way by the data, and in another zip code, policing happens another way, then we can educate the administration on a deficiency in there and ask for a response. If we monitor that response and find it deficient, take it up to the next step. But the data gives the power to move forward because ultimately the job is to close the gap. So I would say that the responsibility is for everyone to do what one can and must do until that gap is eliminated, as evidenced by the data.
Who's a part of this policing project?
Like, who's on it? Who's a...
Barry Friedman is the individual from New York University School of Law. They provided us with, and I'm not quite sure how public this handout is that they gave to us, so my recommendation is at this point, commissioners make an appointment to meet with the executive director to see that paperwork, and as soon as we have the ability to make it public, we will do that or urge the city to do so. But as I'm understanding it, they have at least 3 staff persons, 2 of whom they brought with us and we met, and then they gave us a sheet with up to 15 other academics from around the country who we were told are skilled academics and scholars who are volunteering their time. I do not understand that the policing project is volunteering their time. I think we have been given to understand that somehow the public funds that are to be expended for their work are coming from the police department budget, but that's just to the best we understand. But that's what we've been told, is that there is human hope. I mean, we can just show that. It's like this, that you can look at, right? And so that's who they are. Now, the next step that I heard, I'm sorry, Commissioner, and I'll let you go. The next step that I heard is that the mayor has asked for a task force of citizens or
Steering committee.
Steering committee, 12-person steering committee be assembled. And one of the parting questions to those who were assembled at this meeting last week is, who should be on that committee, either individuals or by role definition? So I think that the next step in this work is they're trying to figure out who's on the steering committee and then how that goes forward. Commissioner
The
Poster.
only thing I would add is Professor Friedman was here 6 weeks ago and met with different groups in our community, and evidently the process employed is a very similar process to what he's used in other cities. So there is already a prototype that he recommended to the city. How close this is to what he's done in Cincinnati or elsewhere, I don't know. But his background, having worked at Vanderbilt, is that he already has the confidence of a number of people in the city.
Commissioner Ali.
Yes, just a question on the task force. Are we being asked to present names of recommendations to the mayor's office for that task force? Because that might be a good thing for us to do.
Well, I believe that names would be accepted forward. I think that that's an answer. Yes.
And just for clarity, there is the Policing Project Nashville team, the people who are going to be doing the analysis, but there's also the proposal to have a local steering committee of community members.
Right, I understand.
Right.
And I'm talking about putting names forward for that.
For the steering committee.
The steering committee.
Yes.
Yeah, there's 12 people.
Yes, and I think that not only are they open to suggestions for particular people, I think that there is still a space right now for recommendations on the process by which those individuals will be identified.
Mm-hmm.
Exactly.
So certainly, do we want to, right, if you have a recommendation for how steering committee members should be chosen, I think we'd be happy to take that to them.
My last point, responding to Commissioner Poster, and I'm sorry that he is not here to hear it, is while it is true that the principal investigator in this project does have roots in this city and roots with an institution in this city, one of the questions that we raised specifically on your behalf when we looked at the roster and the institutions represented around the country was a noticeable lack of any participants from HBCUs, historically black colleges and universities, and this was followed with a commentary that racialized differences in policing look different in different jurisdictions, so that if there are issues in Chicago or Cincinnati or elsewhere that were inflected by race, that does not mean that they are exactly similar to those issues in Nashville. And since we do have at least 4 HBCUs here, and since they're going regionally, that we need not limit the view there, but there are fine institutions in Atlanta, Washington, D.C., and others that need to be contemplated. And that recommendation was heard and accepted, and we were told that they would move towards that level of inclusivity as well. Okay? Thank you,
Great.
ma'am.
Yes, and I asked Barry Friedman if we could share the information that he provided, and
He did say
it was a
yes.
robust yes.
Yes.
So
We'll
I will
share
be
that.
happy to copy the handouts that he passed out and share them with all of you.
Thank you.
Great. I'm don't want to catch her off guard. I'm very excited to introduce you to our new team member. We have a, yes, Sarah, if you wouldn't mind standing for a moment. Sarah Imran, a recent graduate from Vanderbilt Peabody, is our new Director of Policy and Research. I'm thrilled to have the position filled. And I think we've been running her ragged in the past couple weeks. So thank you. I wanted you all to be able to see her. And if you received our email, I think it was last week, with her picture and some more information about her. So welcome, Sarah.
Thank you, Sarah. Welcome.
Very quickly, a couple of events. I think, Barbara, if you would not mind, you're going to have to get a microphone if you want to. Thank you. Friday, our office co-sponsored an event commemorating World AIDS Day. And Barbara was deeply involved in that event. So if you would please give a little wrap up.
Yes, can you hear me okay?
Yes.
All right. It was phenomenal. It was a wonderful collaboration with several area community partners, including Meharry Medical and Vanderbilt and Ray of Hope and Streetworks and many, many others. And it was an opportunity to really look at this pandemic of HIV and AIDS and how it is still a scourge on the community, particularly in communities of color regarding stigma. And Sarah was there, Ryan Klein, one of Commissioner Board Chair Hildreth's students was there. 3 Metro Council people attended and stayed until the end. Sharon Hurt, Bill Withers, and Tanaka Vercher, yes. And so they stayed all evening. So it was really, really wonderful and well attended. And we enjoyed these types of collaborations. Thank you.
Thank you. And this Thursday, we are co-sponsoring the Human Rights Day celebration. There are a few tickets left, so please get your tickets if you want to come. It's a really nice event. And I wish I could tell you how many years now we have done it. It predated me. When I came on, when you hired me, and we did a sort of deep assessment of the programming that our office was doing, this was certainly a program that I found to be beneficial. And speaking of our former board chair, Frank True, there will be a video commemoration acknowledging his work at the event this year. Our next meeting is January 8th, not January 1st, which is in fact the first Monday of the month. But because it's a holiday, it's moved to the following Monday. And while this is well ahead of us, I did want to raise this. Our April meeting is scheduled for April 2nd. I would ask the commission to consider moving that to the following week. If you all agree to that, that first week of April is spring break for public schools. And certainly for personal reasons, being married to a public school teacher. And when you see what we have coming up in March, you will say that lady needs a day off. So, Chair Hildreth, if you would like to do that by consensus or vote, I'll leave that up to you. But I would ask that you consider moving the meeting from April 2nd to April 9th.
Is there a motion to move the calendar from April 2nd to April 9th?
I move.
I'm sorry? Do we have a quorum?
We don't. Okay, well, that's fine. It can be next month.
Thank you.
Great, so consider that, look at your calendars before the next meeting.
If, like, if I would end up being in support of that, but I, for reasons that are already on the calendar, couldn't make the meeting, would that count against my, like, missing a meeting? Do you know what I mean? Because I don't-
Exactly.
I already know the meetings I'm missing this year, and I've told you all, but
We'll find a way to, if I can be reminded for the executive committee agenda in January, if I could be reminded, Ms. Barbara, to ensure that we address that. That can be a no fault.
And we could also do a little poll of commissioners to ensure that we will have quorum on April 9th. Because if not, I understand that it's it was a courtesy, but not a necessity. Great.
Next week.
Oh, yes. So, yes, thank you very much. Next Wednesday is our Mobile Diversity Seminar with the Police Academy. This will be our 4th seminar. Again, all day. If you have any part of the day that you are interested in attending part of the seminar, please let us know. And I should also then announce that the Police Academy requested that we do an additional Mobile Diversity Seminar in March, which, in full disclosure, was not part of our calendar because we already have a seminar scheduled for them in June. But given the so where we're at fiscally and having now been fully staffed, I believe that we can accommodate that request for an additional seminar. So,
I have a question when you have a moment.
I'm sorry?
the mobile diversity for next week is the 13th.
13th, that's correct.
Commissioner Allen?
Thank you. So I actually have two questions. One question is, because I'm still familiarizing myself with the rules, is it possible to have an agenda item that opens the floor to just general observations and comments that we have and that we're making?
I would gladly accept that we're at the point of public comment now. The public seems to be the members, the commissioners right now, without one other person. So we are now open for public comment. And if you would like to leave that off, you're welcome.
Okay, thanks. So I've seen an increase in cyberbullying in the city, and particularly along racial lines. And I would like to recommend that we focus 2018 on adding monitoring cyberbullying in the city and looking at different models for legislation that address this. For example, Wisconsin has passed a state statute that specifically addresses cyberbullying both for children and adults. And other states have it that's only focusing on children, but I think that the time has come that we start thinking about that to protect our community.
I'm wondering if that would be something that the due process committee could do. So what I would recommend is if you would volunteer to take charge of that issue concern and first schedule a notice meeting with the executive director and the chair of the due process committee to see how best to go forward. Do I understand your concern to rest at the level of legislation/ordinance at the city level, or are you also proposing state legislation as well? All right, because being mindful of the fact that State General Assembly moves into session January 3rd, this is a timely time to think about it, and the way in which for us to process it would, I suggest, be through our committee process, and I think the due process committee is equipped well to do that. Yes, Commissioner Wolford.
When it comes to cyberbullying, I guess my question is anybody else in the city doing that, county doing that at all? Or is this something that's brand new, because it seems to be a big issue?
My understanding is nobody's addressing it.
Not even the school system.
Well, I don't know if the school system is or not, but I'm seeing actually the biggest increase with adults.
Right.
And the school systems, if they're addressing it, they're not going to address adults.
Chair's prerogative, we have knowledge that is beginning to come in sideways to the commission about persons in the public who are allegedly being bullied by members of Metro government in public, not public media, social media. So this is not a schools issue. This is not a schools issue, and this is an issue that has legs in other jurisdictions around the country, so it is an item. There are ways in which it can be responded, and so what I'm suggesting is that Commissioner Ali take that up on our behalf, and any other commissioner who is interested in this is welcome to join her. So if it gets calendared through the due process, you guys are giving me a high sign, and am I messing up over here? No. Okay. Calendared through that committee, then any other commissioner who's interested, make sure you respond to the notice of that meeting, attend and flesh out those questions. What are the metes and bounds? What does this look like? What are potential responses?
I have a quick question, comment. To piggyback off the cyberbullying, can we put on the agenda for January to revisit the idea of choose civility that we discussed before, that would encourage, just basic civility, and even have, Metro get involved and sign off on that, like we discussed a year or so ago when I brought that up. I think
I would accept that as an amended, an agenda item for the executive committee in January.
Okay.
And have the executive spend some time, get in the weeds with it, and figure out how it moves forward.
Okay.
Yes.
And I would also add that if commissioners have information or data sets that they want to share with our office, that might be able to provide some direction to our policy and research folks, to sort of perhaps gather some research, maybe do a little white paper for us on the current state of the cyberbullying and who's working on it in the city.
I think that would be really helpful for those of us who didn't really know.
Like an issue paper.
Yeah.
Right.
Yeah, it's alarming. It's concerning.
Yeah. And I would remind commissioners that while my office may not be able to respond to absolutely every request, if there are issues that really sort of rise to the top that you feel having an issue paper or a white paper, issued from our office on, please bring that to my office.
And that's not just tied to the meetings. You don't have to come and move that into, you can go directly to the executive director. Mindful of the time, it's just past 5:30. Do we have?
I just have a question.
Yes.
I think that I might have read quickly and then not had time to address it. So I just want to clarify, when we have these education meetings, it is not a time where we can draw questions at the moment. Is that right? Because I remember something coming out saying that if you have specific questions that you would like to be addressed at the meeting, that we should send those to you prior to. And for me, I wasn't totally sure that I would or whatever. But even today, even if I didn't have a deeper question, and I know that you said get our questions to you within 7 days, some of my questions were just like really easy clarification questions that I would have liked an opportunity to be able to direct. And so moving forward, is that not going to happen?
So let me, I'm going to take responsibility for this, and let me say, we had to negotiate the terms of this particular conversation because, as we indicated, we had one governmental function that was split and shared by two diametrically opposed entities. And there was a concern that that would move into a debate, an opportunity to be targeted, and all sorts of other things. And as you see, we're already learning, like, in the interest of time and trying to keep clean this very good tool that you are developing here, we made an executive decision to make sure, to offer an assurance that this was an education system, not a debate, and then to keep that clean. As I mentioned before, in education sessions going forward, ordinarily there's only going to be one group, and so if we have the time, it would be much easier to ask the questions, right? Does that make sense?
Yeah.
But this time, because for the reasons I stated, what happened happened, and I take responsibility for that. And if I'm wrong, I apologize. But it was there was a rational basis for the struck for today.
I think that in general, that was, I thank you for the reiteration and for the choice. I think that something like, why is domestic violence, like what happened to the very courageous Sparkle Johnson, something that is even considered a misdemeanor? I mean, I didn't understand like the basic things of how's that next to a DUI? You know what I'm saying? So things like that would have been a nice ability to just get some kind of clarification.
Although part of what we would do is try to put out prep information before and have prep after, because one of the difficulties is here is with our diversity. We're 17 commissioners coming from different places. We're going to come up with issues that are going to be inside sports for half of us and completely new territory for the other.
Right.
And it is not the responsibility, the role, nor fair to spend time to bring up those of us who, you're like, when we do finance, I won't have any idea what's going on.
Right.
It's not the job of the public meeting to bring me up on how a balance sheet works for that. And so that is why your executive director did send you information out about bail beforehand, and would love to hear from you afterwards. But how does stuff work may not be always answered in this, would be my
Can I say
statement.
something real quick too? Do you think it's possible that we can have a follow-up session? It can be a closed one without the cameras, because, you know, it would have been nice.
It's public.
Okay, it would have been nice if the district attorney, no, the public defender would have had someone come up and show that how they are affected.
You gave her an opportunity.
Yeah,
So-
you know, it would have been nice.
I'm going to take some time with this because this is important. I'm hearing that we are being victims of our success here because we started educating ourselves and we opened up our curiosity about
Yeah.
things we don't understand.
Yeah.
At the
more clarity.
same time, the summary questions I asked at the end were designed to, if we want to learn more about this, this is how we can do it, and this is where we can go. I will also say that what happened was not necessarily what we asked for and was agreed for.
Yes.
And that the
That's-
bringing in a lot of stories would have taken potentially this forum, our time, the focus into other places that go beyond what we're trying to do. Sometimes we can be most effective by being disciplined and staying within some limits.
Well, my problem was that they pretty much knew that there was a
Contention.
contention going on.
Yeah.
So now they were addressing what that contention was, and we had no idea what they were.
Well,
I didn't have any idea what
excuse
the
me,
issue
if,
was.
order, if I can have some order. What I would say to that is that your executive director sent you information in advance. And again, we all have different levels of interest, but we did provide enough information to kind of get a flag that there might be something going on. So even if it doesn't, I know I'm not going to completely address the concern, but I'm putting it out there is that we brought forward a topic that has different dynamics to it, and we tried to make sure that commissioners had that information without flagging the difficulty, because if we flag the difficulty itself, we're necessarily taking sides. This is what happened, is what needs to happen. Maybe part of the education here was finding out that there is a problem, a difference of opinion, two diametrically opposed ways of approaching what seems to be a very facially neutral topic. How does money bail work? So, okay, thank you. If all hearts and minds are clear and we have nothing else, I would move to adjourn the meeting. Thank you.
This has been a service of the Metro Nashville Network. If you would like to see this presentation again, or for more information about this and other programs, visit nashville.gov.